Just going to give it a quick minute for everyone to trickle in, and then we'll get started.
All right. Very good.
Okay, I'll go ahead and kick it off. So I just want to welcome everyone to our third Federalist Society event of the semester. For those of you who aren't familiar with FedSoc, we are a law and public policy group founded on principles of freedom, judicial restraint, and separation of powers. On that note, we have a really interesting discussion tonight on all three branches of government, but especially the executive. So if you enjoyed tonight's event, please consider joining FedSoc. The info on how to sign up is in the chat. So with that, I want to jump right into our speaker for the night. I'll introduce Mr. Ray and ask him some questions for the first 40 minutes or so, and then we'll save some time at the end for your questions. So please put any questions you have throughout the event in the Q&A function of Zoom. And with that, I'll introduce Mr. Ray, our speaker for tonight. Paul J. Ray is a senior advisor at Potomac Global Partners and is a leading authority on federal administrative practice, law, and policy. Mr. Ray joined Potomac from the Office of Management and Budget's Office of Information and Regulatory Affairs. We'll call it OIRA for short, because that's kind of a mouthful. So he served there as the administrator, and before he served as acting administrator and associate administrator. In those roles, he oversaw the review of hundreds of regulations, led federal efforts on regulatory reform, frequently engaged with members of Congress, as well as companies, nonprofits, and other stakeholders in the private sector. Before joining OIRA in 2018, he served as counselor to the US Secretary of Labor, where he focused on legal and policy issues related to regulations. He was also previously an associate at Sidley Austin and clerked for Justice Alito at the Supreme Court, and now Chief Judge Livingston of the Second Circuit. So even though he didn't go to Texas, he went to a great law school, Harvard Law School, where he served as editor on the Harvard Law Review and the Harvard Journal of Law and Public Policy. So with that, I want to jump right into questions. So Paul, could you tell us, for those who aren't really familiar with the office, a little bit about what OIRA does and what your role was there?
Yeah, happy to. And first of all, Paige, thanks for the invitation, and wonderful to join you all here today by digital proxy. Sorry, I can't be in person, but of course we want to make sure to keep everyone safe. So glad to take this this method and opportunity to meet with you all. So OIRA, and Paige is correct. That's how you say it. I heard all sorts of things on the Hill, like ORA and OIRA and all that sort of thing, but OIRA is how you say it. So OIRA has a core function that everyone's familiar with, and then a number of other very important functions that folks are less familiar with. The core function is the review of regulations from most executive agencies. It does not review regulations from the independent agencies, but it reviews regulations from all other agencies, and it reviews regulations that are we can just say, for our purposes, the most important regulations. They could be important for economic reasons, they could be important for policy reasons, but the bottom line is OIRA is tasked with reviewing the most important regulations from the executive branch, non-independent agencies. OIRA also has a number of other roles. Among the most important other roles is the approval of the forms that every federal agency, non-independent and independent alike, issues. So if you've had to fill out a federal form and you thought it was a wonderful experience, you should thank OIRA for that. If you thought it was not a wonderful experience, you should blame the agency for that. I'm kidding, of course. So OIRA does have to approve all those forms before they can be used. OIRA is tasked also with running point for the federal government on many aspects of privacy policy, on science and statistical policy as well. So a lot of very important functions there. I'll talk for a brief moment about the function for which OIRA is best known, which is its regulatory review function. That function is governed by Executive Order 12866, which was issued by President Clinton and has been retained by every administration since then. It's a relatively rare example of bipartisan consensus in the administrative law and policy space. I recommend to all of you a wonderful article by one of my predecessors, Cass Sunstein, on OIRA's regulatory review function. A lot of folks have the impression that regulatory review essentially is the same thing as cost-benefit analysis. And OIRA is known for its cost-benefit analysis, and that is an important thing that OIRA does. It's an important part of regulatory review, but it's not the only part of regulatory review. An equally important, and in many in the case of many particular reviews, a more important aspect of OIRA review is the aggregation of views from across the federal government. So suppose OIRA receives a draft regulation from the Department of Health and Human Services with regard to health insurance. So OIRA would perform a cost-benefit review of that regulation, but it would also send the regulation to a bunch of other actors within the executive branch. It would certainly ask for the views of the Department of Labor due to labor's authority in the pension context, which is related to health insurance plans. It would certainly ask Treasury to review the rule due to the tax implications of health insurance plans. It would probably solicit views from the Department of Justice, White House Counsel, the Domestic Policy Council, the National Economic Council, and possibly a number of other executive actors. And it would aggregate those views and adjudicate disputes among the agencies. And this aggregative and dispute resolution function is often an underappreciated aspect of OIRA's role that I stress here due to its importance.
Thank you. So yeah, speaking of things that are underappreciated, regulatory reform isn't always the most headline-grabbing topic. So can you tell us a little bit about why it's so important and why we as law students should care about regulatory reform?
Yeah, of course. It's a good question. Thanks, Paige. So, you know, the most obvious reason would be that every American is impacted every day by regulations. They are impacted when regulations work well, when they are protected from harms and bad actors by regulations, and they're impacted when regulations don't work very well. Their possibilities to earn money for their families and create products that Americans value can be adversely impacted. That is reason enough to care about regulatory reform. I want to posit for you a different reason. It's the reason that I personally was keen on the role at OIRA, and that is that regulatory reform has a lot to do with one of the most fundamental questions in political life, which is who decides what's going to happen in particular contexts. It seems to me that there's a powerful case to be made, and I tried to make this case in the administration, that there's a core aspect of human thriving that's instantiated, among other ways, by getting to make decisions for oneself and in one's community. And regulatory reform has a lot to say about that issue. I don't know if we have any John Finnis readers on this webinar, but what Finnis would call the basic human good of practical reasonableness can be instantiated in really serious ways in the act of governance, in the act of self-governance, making decisions for oneself and one's community or communities. And the possibility of instantiating that basic human good really turns in significant part on issues of regulatory reform. So for me, this issue of human thriving was even more important than the other nevertheless very compelling reasons to be interested in regulatory reform.
Yes, so you mentioned that compelling reason of it affecting everyone's lives. What are some real life examples that maybe worked on at OIRA that had an unfair or negative effect on people, just everyday people?
Yeah, yeah. So one of my favorite examples was the Waters of the United States rule. Um, this is a rule that some of you probably know from the Obama administration that pretty significantly expanded the reach of federal jurisdiction over waterways. It didn't actually pertain to the question of what waterways would receive protection or which waterways or what protection they would receive. And that's because the question of whether federal jurisdiction exists is a separate question from whether whichever entity that has jurisdiction, whether it's the federal government, state government, or local government, will set protective standards and what those protective standards will be. The Waters of the U.S. rule was just about who the decision maker will be for the kinds of protections that are afforded. And the Waters of the U.S. rule from the previous administration took a posture that the federal government should be the decision maker for a number of pretty minor, purely intrastate waterways, and that seemed very problematic due to the inefficiencies it created. Often DC doesn't know very well what the needs of particular local communities are, but more so because the communities that actually depend on the water for their well-being seem seem to have a really core interest, even a right, in deciding what to do with those waters. I think of a conversation with a centrist U.S. senator who said, "Well, you know, why can't we be trusted to take care of our own natural resources? And we live among them. We use them. Our lives depend on them. Shouldn't we have essentially the dignity of being allowed to make those decisions?"
It's a really good example. And I guess kind of going back to your point about who decides, what do you think are some of the constitutional issues with the administrative state? Should the president decide, should Congress, should the judiciary, or should, like you mentioned in your example, should the people using the resources decide?
Yeah, yeah, no, great question. I think there are a number of constitutional issues posed by current administrative practice, and strongly suspect that the folks on this webinar have debated a number of those. What I'd like to draw your attention to is one that I had not thought about when I was a law student, but as I've practiced, I've seen that its practical implications are quite significant. And it sounds in separation of powers. So there's a line in it's Federalist 57 that it's a really striking line, an example of high rhetoric. But it says, if a people will tolerate something like restrictions that are or different restrictions on the people than apply to the legislature, to the lawmaker, they'll be prepared for anything but liberty. And I read that line again a few years ago, and it really struck me because a regulation is definitionally almost a standard that applies differently to the regulated than to the regulator. It applies differently in a number of ways. But the way I'd like to focus on right now is that the regulation imposes restrictions and confers enforcement authority, often in inverse proportion. That is to say, what the regulation cedes to the regulated parties, it withholds from the agency's own enforcement power, and vice versa. So here's an example, very, very common example. Agencies, when crafting regulations, very, very often like to include what's sometimes referred to as a sweepings clause at the end of a long list of prohibitions. So a regulation will say, particular sort of enterprise shall not do the following 7 things. And then there's an 8th entry for anything that is like the foregoing 7 things. I'm sure you've all encountered these kinds of sweepings clauses before. And the reason agencies will tell you that they include those is they're very worried that they will that some sort of problematic conduct will arise, that if they'd known about it, they would have prohibited, but they didn't think of it when they're drafting the regulation. It's a sensible reason from their perspective to include a sweepings clause. The problem is that it creates immense uncertainty among regulated parties. What exactly falls within the sweepings clause? And this issue is an example of a situation where the interest of the agency in being able to enforce broadly is precisely inverse to the interest of many of the regulated parties in having clarity and assurance, so they can make the sorts of decisions they need to make to run their businesses or their lives. So the point is that where the enforcement and essentially the legislative authorities are combined, there are incentives to make rules in particular ways that would be absent if the people making the rules, or essentially making the laws, would be constrained by the rules they're making, as in the same way that the regulated parties are.
So digging in a little bit deeper on that, do you think, I mean, we're all originalists here at FedSoc, do you think that the administrative state that we have now is consistent with how the Constitution was originally understood?
Yeah, I would say no, and among the reasons for that is the difficulty that I just discussed, among a number of others.
So kind of switching gears a little bit, we all heard President Trump talking about draining the swamp. And so going back to your time when you were actually at OIRA, what were some of President Trump's goals and priorities while you were at OIRA?
Yeah, so I would say they fall into 2 main buckets. And one is the bucket of promoting economic growth, so that no American will fail to have a good job and be able to provide for their family because of a federal regulation. And 2 will be regulations that, quite apart from their economic effect, were important to restore the full capacity for self-governance.
And do you have any things that you're most proud of accomplishing during your time there?
Yeah, it's a good question. Thanks, Paige. One of the things I'm most proud of is an executive order that OIRA ran point on, which is Executive Order 13891, dealing with guidance documents. I assume that at least some of the folks on the call are familiar with guidance documents. This order required putting all guidance documents on central web portals, one web portal for each agency or agency component, and putting a legend on the top of each guidance document explaining that while this is the agency's view of the law or of policy, it's not legally binding. So no one is legally obligated to follow the guidance document. These sound like common sense changes, but it's remarkable how impactful they can be. At a number of agencies, guidance was scattered, all across the agency. Some of it online, some of it not online. We even had an agency, as we were preparing the EO for the president's signature, had an agency explain that it strongly objected to the order because it couldn't find all of its guidance. It was impossible. And of course, the response was, well, that's exactly the point of the EO. If you can't find it, then what can the public do? It sounds like a fairly straightforward measure, but I think it really was important to creating transparency, making the government accountable to the people, and and the end result of both of those things is enhancing the ability of people to govern themselves.
So we have a lot of 1Ls on the call, I think. So just for those who might not be familiar with documents, could you just give a quick pitch on how guidance documents are different than rules?
Oh, sure. Yeah. So a guidance document is not a regulation in the sense that the APA uses the term. Some of them probably are regulations, but subject to various APA exceptions, but it's not important right now. Basically, a guidance document does not have the force and effect of law. That's the key piece here. So an agency will issue a guidance document if it wants to explain the way it interprets a particular statute, if it wants to explain a new policy, or for any number of other reasons. The key is they don't have the force and effect of law, and in consequence, they don't need to follow the APA procedure for notice and comment rulemaking. What that means is the agencies can issue them with very little investment of resources, and they can issue them very quickly. And in the past, there have been times when agencies didn't want to invest the resources they needed to in a rule, but nevertheless they wanted to change the way the public viewed its statutory requirements, and so they would issue a guidance document saying that we now interpret the law in this new way, and indeed we may enforce against entities that don't comply with this new view of the law. And so while the guidance document has no force and effect of law, nevertheless a number of entities very much find it in their interest to comply with the agency's views. And so that raises a number of issues. Among them are the transparency issues that I mentioned earlier. Unlike regulations which appear in the Code of Federal Regulations, guidance documents often do not even appear in the Federal Register at all, sort of scattered all over the place. And this sort of scatteredness means that major players who can retain expensive counsel to find all the guidance documents have a really serious advantage vis-a-vis smaller operations. So we wanted to address that in that EO.
Well, that was one of my favorite EOs from the previous administration too.
Well, thank you.
What do you think though were some of the barriers that you faced trying to put these reforms into action?
Yeah, so here I'd have to say, here I want to turn back to the very first thing we talked about on this call, which is that OIRA does a lot more than just cost-benefit analysis. And sometimes there were some of my colleagues at the agencies didn't always understand that when OIRA had a regulation under review for a couple of months, it wasn't simply checking and rechecking the cost-benefit analysis, although it often was working extensively on the cost-benefit analysis. But often it was attempting to resolve some disagreement among the agencies. And I think that confusion was perhaps sometimes more pronounced among the public, to whom it looked like an agency had submitted a regulation and OIRA was just sitting on it, had just sort of taken it into a black box and there it disappeared. And in my experience, that is simply not what OIRA does. And again, Cass's article is great on this, that usually if a regulation is taking a long time, it means there's a disagreement, a serious disagreement to be worked out.
So in addition to some of the internal barriers, what were some of the criticisms of reforms you did? Everything sounds great, more transparency and accountability, but I'm sure you got some more pushback than that. So could you tell us a little bit about sort of the opposing arguments?
Yeah, no, absolutely. I think that probably the strongest objection that we received was that our reforms were leaving Americans unprotected. I think the objections to the WOTUS rule seem a prime example of this. The objection made it sound like once federal jurisdiction of waterways had been eliminated, then it was just a free-for-all. Any waterway that was not subject to federal protection, people would be dumping horrible toxic chemicals into it the next day or something like that. Um, and I find that critique just really misunderstands the way that state and local political processes work, and and perhaps more importantly, just doesn't. I mean, frankly, it just expresses a real mistrust uh, of of non-federal communities, of the states and communities who also have governing power, who also presumably want to do what's best for the people who live there, sometimes even more than the federal government does, presumably. Sometimes they know more about what's best for their communities than the federal government does. And so I thought that the some of the objections came down to the following: that we think state and local governments will do a much worse job than the federal government will do. And there just doesn't seem, in many areas, there doesn't seem to be a reason to believe that.
So I want to switch gears a little bit into some of the other branches. As far as the court goes, what are your thoughts on Chevron deference? Do you agree with deference? Do you disagree? And what do you think that jurisprudence would look like without it?
Yeah. So I do not like the Chevron rule. I think it enables. Well, let me begin by saying I certainly understand the reasons that motivated people like Justice Scalia to be staunch defenders of Chevron. Justice Scalia, I imagine many of you already know this, but for those who don't yet, Justice Scalia was a very staunch defender of Chevron, and he defended it essentially because he thought it got courts out of the business of making contested policy determinations, and put in place of courts for those contested policy decisions people who were ultimately accountable to the president, who is ultimately accountable to the people. So basically, he defended Chevron on democratic grounds. I see the point of that defense of Chevron. Nevertheless, it seems to me that more troubling than judges sometimes deciding questions that could otherwise be left to political actors is the prospect of a single person and his lieutenants making decisions for a tremendous swath of American national life. In other words, it seems troubling that judges would get to make decisions that could be left to political actors, but it seems more troubling that a single political actor gets to make as many decisions as he does. Chevron facilitates the exercise of immense presidential power, and that seems problematic.
So what about the third branch, the legislative branch? What sort of statutory reforms would you recommend in the regulatory space?
Yeah. So one area that we haven't talked much about on this webinar is enforcement and adjudication. Obviously, agencies do a lot more than regulate; they enforce and adjudicate, and it's interesting. There is really serious political accountability for regulatory activity, but much less for enforcement and adjudication activities. And so and there are also not, the APA does not specify very serious protections in the enforcement and adjudication space. Some agencies have adopted them on their own. Some agency organic statutes contain particular procedural protections, but by and large, there are many fewer protections in agency enforcement and adjudication proceedings than, say, in federal court. If you combine that with the fact that there's pretty minimal political accountability for mistakes and even abuse in enforcement and adjudication, it seems to me there's a strong case to be made for statutory reforms for the for agency enforcement and adjudication. So, for instance, I find the Chenery 2 decision very, very troubling. For those who don't know, Chenery 2 held that an agency is permitted to articulate a new interpretation of its statutes or regulations in an adjudication proceeding and apply the new interpretation to the party before it. So in other words, the party before the agency took an action in reliance on a previous interpretation, and the agency can change the interpretation in that very proceeding and apply the new rule to the party that already acted under the old rule. Now that seems it's very troubling, and I would codify a prohibition on that practice. I would legislatively overturn Chenery 2, and there are a number of other modifications I would make. That's just one of the more egregious examples.
Well, thanks. Those are all good examples. It's been fun to talk about regulatory reform, but I think we're all also a little bit curious about you and your experiences clerking both on the Second Circuit and for Justice Alito. So can you tell us, for those of us who are interested in clerking or think they might be interested, how those experiences were and how they helped you in your career?
Yeah, sure. I mean, just amazing. Judge Livingston and Justice Alito are just tremendous. The professional benefits of clerking, I think you guys already know. I found the one benefit that I did not understand before I clerked, but came to understand very well when clerking, was the benefit of being mentored by really amazing public servants. I'm thinking of a time when I interviewed with Justice Alito, and he said, he wouldn't mind me saying this. At one point, we were comparing experiences, and he said, once upon a time I was the U.S. attorney in New Jersey, and then proceeded to tell a story about that time. And I was just really struck by the fact that he had assumed that I wouldn't know that about him. And of course, I had spent months preparing for this interview, right? So I knew everything about him but a social security number, probably at this point. But he didn't have the hubris to assume that that he was such a big deal that I would already know that about him. And that kind of humility and high office that Justice Alito and Judge Livingston both modeled in an amazing way has been one of the best lessons I've received.
And on that note, do you have any other mentors that have been great throughout your career?
Yeah, absolutely. I think of John Manning. He was not the dean at Harvard when I was there. He was a professor, but I had the good fortune to work on a paper under his supervision, and he's just been a real inspiration and mentor. I think of Larry Arnn, who's the president of my college, Hillsdale College. And I think of I also think of people I've never met. I think an author or a statesman who you read about can be a mentor as well. So I really look up to St. Thomas More, Cicero, and others for their work in statesmanship and in the law, and have just learned so much from them, even though we've never exchanged words. Or they've given words to me, I've never reciprocated.
So you mentioned St. Thomas More and Cicero. Do you have any other reading recommendations for students who are interested in regulatory reform, or maybe even broader interested in clerking?
Oh my goodness. I feel like I need to kick back and pour a scotch for that question. We could be here all night. Yeah, so what I tell law students is really, it's so important to become a technically skilled lawyer. That's why you're in law school. But if you are intent on public service, it is absolutely necessary to understand what the purpose of law is. And that, of course, raises questions about the purpose of civic life, what it means, what politics is, what it means to be in a political society, and those questions are really essential for someone who wants to do well in public service. And they're not questions that law school takes up for the most part, and that's as it should be. Law school is principally a professional school, but nevertheless, it's really important that you understand, that you think really seriously about these things. So I mentioned John Finnis earlier. I think his Natural Law and Natural Rights is really, really excellent. I don't agree with him on everything. I don't expect that we all would either, but a number of his insights were really eye-opening for me when I read the book. So I think that's a fine place to start. I've gone back to Aristotle in the Ethics and the Politics many times over the years. I always find that a very rewarding, enriching experience, and in particular, his notion of the role of prudence as a kind of human thriving, and his notion that kind of prudence finds a certain kind of exercise, a very important kind of exercise in civic life. And so, I found that very, very instructive. In terms of other more modern authors, Jacques Maritain, who's a French mid-20th century political philosopher, one of the minds behind the UN Declaration of Human Rights. I find his thinking on the ends of law and civil society very, very illuminating.
Those are all great recommendations. We'll definitely have some books to add to my reading list over the week. So I have one final question, and then we'll turn it over to the audience Q&A, but mine is just very general. Do you have any other advice for law students and young lawyers?
Yeah. Law school and legal practice are not all there is. Law school feels like it's all there is to you right now. It felt like it's all there is to me when I was there, and you should work really, really hard. I'm sure you are. There is more to life than law school. There is friendship, there is the beauty of nature and art, and I really encourage everyone to stop often and reflect on what are the reasons that you're pursuing a legal education, because those reasons, if they're good reasons, will be bigger things than law school itself. Trying to think of how to explain this. Law school is a means to something, a means to some end. Presumably the end is more important than the means that get you there. But it can be very, very tempting to focus so much on the means, because you need to be good at the means. You need to do well in law school. You need to do well in legal practice. It can be so easy to focus so intently on the means that you lose sight of the end, and you allow excellence at the means to displace enjoyment of the ends. So if you are pursuing a law degree because you want to do good for your community, then go spend time in your community. I mean, it's a meme in DC that people come to DC to do good for their communities back home, and then they stay here and never leave, and they lose touch with those communities. And that is a horrible, horrible thing. If you're going to law school to support a family, spend time with your family. focus most of all on engaging in the end that law school is a means for.
Well, thank you. That's a really great answer that I don't hear much, so I really appreciate that. I think we should turn it over to audience Q&A now. So we have a couple of questions in the chat. The first one's from Warren Bloom. Warren asks, what area of regulation do you think has gone most far? In particular, regulations, one, that you find most troubling practically, and two, most troubling constitutionally.
Yeah, no, great question. Thank you, Warren. So it is not the content of any one regulation that I find most troubling, but rather the fact that they are being made at the federal level at all. There are many decisions made either by Congress or the agencies that, if what we've said about the need for, as much as possible for each American to be involved in self-governance in a really serious way, if that's true, then we want as many decisions to be made at a local or state level as we can have. And that's pretty far from where we are today. So it really is the thing that I find most troubling is who's making the decisions rather than the substance of the decisions that are made. Yeah.
Okay, our next question is from Sophia Shams. It's a bit of a long one, so bear with me. If advocates of Chevron deference look to congressional intent for what body should be interpreting a law, the executive or the judicial, doesn't that seem to lend to how the law should be interpreted? And if so, if Congress intended for deference to the executive, shouldn't the court follow that? Or would you say that the express intent for deference by Congress is in itself unconstitutional and not something that Congress has the power to do?
Right. So the last point raises a question of tension between Chevron and the non-delegation doctrine, and I'm going to put that aside at least for right now. It's a fine question. It's tricky because the creation of Chevron. So certainly in a post-Chevron world, Congress knows it's acting against the background of Chevron. But of course, in a pre-Chevron world, that can't justify Chevron, obviously. Chevron seems to, even though the court in Chevron did say we presume that Congress has this intent, that doesn't seem to have been based on an interpretation of a statute so much as a sort of common law articulation of an interpretive principle. In other words, Chevron wasn't really deriving the presumption that Congress intended deference from the interpretation of a statute as we would normally understand interpretation. It was coming up with a rule of with a legal presumption that in turn was based, it seems to me, based on its views of good policy. But with that said, in a post-Chevron world, clearly Congress does have that presupposition. That's why I would prefer Chevron to be legislatively overruled. That seems the soundest approach, and it would also show Congress reasserting itself as I think it ought in this area. But even if Congress didn't act, I think the judiciary, given that it's a judicial creation, and while Congress has not, it's been acting against the basis of the rule, but it hasn't actually formally embraced the rule. That is to say, it hasn't enacted statutes that expressly rely on Chevron. I think given that it's a judicial creation, I think it would be suitably subject to judicial destruction as well.
So kind of related, another court question, what opinion do you have regarding our deference in the Kisor case, specifically the 5-part test decided by or provided by Justice Kagan?
Yeah. I think Justice Kagan's test is a move in the right direction. I would have supported going further than she did, but I think it's a move in the right direction.
Next question from Corey Fish. Thoughts on early Biden administration regulatory actions? Is he rolling back executive orders? And are there any changes to cost benefit analysis that you want to discuss?
Yeah, well, I wish he hadn't rescinded EO 13891 on guidance. I don't think there was a good reason for that. Obviously, I liked EO 13771, the 2-for-1 EO. I think everyone sort of knew that President Biden would rescind that order, and that's fair enough. But I didn't think there was a good reason to rescind EO 13891, and indeed it had garnered some praise on the left as well as a common sense procedural reform, and since then I haven't heard a good explanation for that by the administration. So that's the change that I was most surprised by and disappointed by. In terms of cost benefit analysis, there was a directive on January 20 to OMB to retool cost benefit analysis in some way. OMB hasn't put out a proposal on that yet, so we don't know what that will look like. But I think it's a thing to watch with close attention.
Next question is from Alexander Nutt. As far as regulatory agencies, what are your opinions on international agencies? How does something like the UN or EU stack up to the US model?
That's a good question. They seem to be engaged in just very, very different tasks. The UN obviously is about collaboration and cooperation between agencies. In this discussion, we've been discussing, the regulations applicable to domestic activities. The aims that those kinds of activities aim at are very different. One is the exercise of sovereignty, one is not, and so unsurprisingly find a really significant difference in the approach to governance in those bodies, and that seems appropriate to me. I'm all for efficiency savings from cooperation between countries, but it seems like it ought to be the free choice of each country to adhere to those international standards that produce efficiencies.
And we have time for the one final question from Boniver Taylor. You've talked about your enthusiasm for classical authors. How do you think ancient Greek and Roman conceptions of law differed from ours?
Oh my goodness. Great question. I wish we had more time. And that really begs the question of what we think law is. I don't know that in America we have a uniform conception of what law is. I think we probably don't. In the classical world, it was very, very common to assert, and this was true in the medieval world as well, it was very, very common to assert that the law was designed to promote substantive goods. Obviously, the good of virtue, for instance. We don't often talk that way now, but nevertheless, it seems like many of our laws are about substantive goods. I think the Constitution is about certain substantive goods, among them creating freedom in which the human good of practicable reasonableness or prudence can flourish through self-governance. So, we're probably closer to the classical authors than sometimes the way we talk about law would suggest. At the same time, I think it's true that we have radically divergent views about what the purpose of law is. I don't think there's a sort of monolithic modern understanding. Great question.
Well, I wish we had more time to talk, but we're running low. So, Paul, I just want to thank you so much for this great conversation. We really loved having you, and appreciate you being here.
Well, really a pleasure to join you all, and everyone, please stay safe and enjoy the semester.
Thank you.
Thanks, guys.
Before we hop off, I'm just going to give a quick pitch to our FedSoc members. Our next event is next Wednesday, September 29th at 7. We'll be speaking with Judge Southwick and Andrew Davis, who's Chief Counsel to Senator Ted Cruz. So it'll be a really good event. The registration link is in the chat. We hope to see you there.